сьогодні з вами зібралися на панельній
Today,
дискусії,
we
яка
have gathered
присвячена
for panel
правам людини в
discussion
цифрову
on the
епоху.
topic of human
І
rights in
на нас
digital
чекає 2 дні.
age.
Я
And
сподіваюся,
we're
плідної
about to
дискусії, а як
spend
інакше,
2 very productive
на цю
days
тематику. У
with
нас
very
будуть
insightful
спікери
discussions
і
around
з
this
України,
topic.
і наші
We're
колеги з
about to have
кордону. Це
speakers
будуть спікери
representing
і
Ukrainian
з Литви,
community and
і
colleagues
з
from abroad,
і з
speakers
Сполучених
from
Штатів
Lithuania,
Америки,
from Cyprus,
і
and
з
from United States of
Швеції, і
America,
з інших
uh,
країн.
and
І
Sweden
я
and
думаю,
other
що ми
countries as well.
забезпечимо максимальне
I'm
охоплення
sure that we will have
найрізноманітніших тематик
the
в
largest,
контексті
the
якраз
broadest
як справжньої
outreach
цифрової
of
епохи.
all possible
І
topics in
я
the
сподіваюся
context
на
of
те,
human
що
rights
дійсно
in
ми
digital
будемо
age.
працювати в
And I
максимально
hope
такому інтерактивному
that we will
дусі,
have
який
very
передбачає
interactive
не тільки
format.
виступи наших
So,
шановних спікерів,
not
а
just
також і ще
presentations,
і
but our
активне
honorable
залучення вас
speakers,
до нашої
but
дискусії.
also proactive
Наш
participation of you,
сьогоднішній і
our
завтрашній захід
listeners, in the
буде
discussions.
записуватися
This
і буде
event and our
транслюватися на
tomorrow
YouTube.
event
Я
will be
сподіваюся,
recorded
що
and
для
live
цього це не
streamed on
викличе
YouTube.
ніяких таких
I hope
негативних моментів і не буде
it won't be a
створювати
problem
якийсь
for you
дискомфорт. Якщо
and you
хтось із
will feel
спікерів не
comfortable
бажає
with it.
його
If
записувати,
some
будь
of the
ласка, повідомте про
presenters
це.
don't
Це
want
можна
to be
написати в
recorded,
чаті
please
заздалегідь.
let me
І
know.
на
You
час
can
вашого
just
виступу
post it in
ми
the chat, so
призупинимо
during your
запис.
presentation we will
Також
temporarily stop the
повідомляю вас
recording.
із організаційних
Also,
моментів,
another
що
housekeeping
наша дискусія
thing, please
супроводжується синхронним
remember
перекладом.
that we
Я
have
вітаю
simultaneous
наших шановних
conference
перекладачів пані
interpretation for
Христину і
this
пані
discussion.
Катерину.
We have
Дуже дякуємо
interpreters,
їм
Christina
за
and
забезпечення
Katerina.
наш
We
сьогоднішній
appreciate the
захід
technical team
якісним
for
перекладом. Уже в
providing
інтенсиві
high-quality
співпрацюємо з цими
adaptation
перекладачами і
for our
наразі
event.
тільки
We have worked for
класно
many years with these
виходить
language service
перекладати
providers,
наші
and
складні
we
юридичні
appreciate
терміни і
high-quality
вчасно
translation of our
навіть такі, знаєте,
complicated legal
заплутані
topics and
речення,
sometimes
як кажуть, знаєте, якщо
confused sentences.
читаєш 10 разів один і той
And
самий текст,
sometimes,
то
because
і нічого не
sometimes
розумієш,
you
напевно,
can,
записав юрист.
if you
От
there is a
коли
saying, if you read
усно
the same
щось
text 10
проговорюємо, то
times and don't
іноді
understand something, it means it's written by a
Іноді
lawyer.
наші шановні перекладачі
Sometimes the
все-таки з
same
цим справляються.
happens
Тому,
in a
щоб
verbal
послухати
speech,
ту
nevertheless,
версію
our
мови,
interpreters
яка
manage the language.
приєднався до нас,
I will
доєднався
kindly ask
а
those
не через
joining
телефон.
us
Ви
on a
можете
computer,
побачити
on a
внизу
PC,
на
not a
таблиці
smartphone, please take a
значок
look at the bottom
глобус,
panel of your
переклад.
screen
І
and
ви
you will
можете
see the globe
переключати
item
ту мовну
interpretation.
доріжку, яка вас
So
цікавить.
please pick
Англійська
the
або українська.
language channel
І
you
в такий
prefer,
спосіб ви
English or Ukrainian.
побачите, почуєте те, що вас
That's how
цікавить.
you
Та
will be
мовна
able
версія, яка вас
to listen to
цікавить.
the event in the
Що у
language
нас
of your
іще з
preference.
організаційних
So,
моментів?
what
Прошу
else do we
всіх
have?
заздалегідь
I will
вимкнути
kindly
мікрофони.
ask
Звісно,
everyone
я
to
можу
mute your
вимкнути
microphones.
мікрофони,
Of course, I
але
can
це
mute you
займає
myself,
певний час,
but it
поки я
takes time
відшукаю,
and
хто з
effort
нас вимкнув
because I
мікрофон,
need
і
to first
він з якого
identify a
вікна
person
виходить
with
без шуму. Це
unmuted
займає певний
microphone
час, це
causing noise.
трошки
No,
дезорієнтує
it
спікера.
takes
Тому
time,
давайте
it
одразу з вами
distracts our
домовимося, що
presenter,
мікрофони
so
ми
we will
зараз
kindly
вимкнемо.
ask
Як тільки у
everyone to
нас
mute
почнеться
yourself. As
дискусія,
soon as
обговорення,
the
звісно, не
discussion
забувайте
starts,
вмикати мікрофон,
please
якщо ви хочете
don't
поставити
forget
те
to
чи інше
unmute yourself
питання.
if you want to ask a
Що
question.
ще?
What
Стосовно
else?
модерації
As for
сьогоднішнього заходу,
moderation
на
of
жаль,
our today
з
event,
певних таких самих
unfortunately,
причин
due to
основна
family
модераторка пані
reasons,
Юлія
our
Розмітаєва
primary
не змогла
moderator, Miss
сьогодні
Yulia
долучитися до
Razmitaeva,
нас,
could not
тому
join us today.
модерацію буду
Therefore,
виконувати я.
I will
А
be the one
оскільки в мене теж
moderating
є
our
певні
event,
сімейні
and
причини,
since I also
виходить
have
з п'ятимісячною
certain
дитинкою,
family
то
circumstances,
ніяк не
namely
справитися без ще
months
одного
old child,
модератора,
I
яким
definitely need
буде
the
сьогодні
support of my
наш шановний
colleague.
Богдан Петрович
So,
Карнаух,
Mr.
ви його
Bogdan
бачите.
Petrovich Karnauh will
Богдан
assist
Петрович
me
є
today.
доктором юридичних
Bogdan
наук,
Petrovich is a doctor of
офіс-директором
legal science,
кафедри
assistant
цивільного
professor at the Civil Law
Національного юридичного
Department
університету імені
of the
Ярослава Мудрого.
Yaroslav
Сфера
Mudry
його
National
наукових
Legal
інтересів є
University.
дуже широкою,
His
і в тому
area
числі
of scientific
охоплює
focus
і
is very
права
broad
людини в цифрову
and
епоху,
covers
чого
human
ви могли
rights in digital
переконатися
age as well.
на заході, який також
And
нещодавно проводився в рамках нашого he also participated in another event held as part of a legal forum workshop on right forgottens. If you join us on Tuesday or on Wednesday, probably Bogdan's presentation. So let us start. I see our honorable speakers joining us.
I see that we have Gintare Samuele now with us. Hello, Gintare. Nice to meet you. At
Hello.
least in
Yeah,
Zoom.
nice to meet you too.
We hope we all yes, we all hope that soon, very soon, we will have an opportunity to meet together offline. And I'm sure that maybe in the closest future, we will have an opportunity to meet in our native city in Kharkiv. We all hope that all these safety issues, they will let us welcome our guests in our native city. So we're really glad to start this panel discussion, which will be devoted to human rights in digital era. You all have the program of this discussion, and you all have you all have the action plan, which we would like to introduce in the end of this panel discussion today and tomorrow. So please feel free to join in the discussion concerning our action plan, which we are going to discuss in the end, as I have already mentioned. So I think that we can start. And I will start by introducing the project within which this and other panel discussions, previous panel discussions, were organized. Я повернуся до
I will now
української
switch back
мови.
to Ukrainian language.
And also, Professor Gintare, you can switch the language version because we have the synchronous translation, and I hope that it will be comfortable for you to listen to us using English version. Now I want to switch back to Ukrainian so as not to take too much time for organizational issues, because my English is slower than my Ukrainian. That's why I do not want to waste our time. So please switch into English. You can see the globe. Yeah, the globe sign behind. Yes, and you can switch. Okay.
So
Да, я повернуся
now
до
I will
української
switch
мови
back to
і
Ukrainian
скажу
and
кілька
I
слів про неї.
want
Пане Владиславе, я зараз
Mr.
щиро дякую.
Okay, thank you so much. So let's remember about our
Я
microphone mute rule.
хотіла би декілька
So,
слів сказати про
checked,
можливе проведення
which
цього
enabled
заходу і
this event
тимчасової
and not
публічної
this one, our
дискусії,
previous panel
які
discussions
проводилися в
as
межах
well,
7-го і 8-го
held as
Харківського
part
юридичного
of
форуму про
7th
свободу
and
і
8th
позаминулих
Kharkiv Legal
днів.
Forum,
Це проект
last year and year before
Erasmus,
last.
Жан
Last,
Моне
this is
18,
Erasmus Jean
який
Monnet
називається
Excellence
Європейські
Center
фундаментальні
project,
цінності в
which
цифрову
called
епоху. Ви всі,
European
напевно,
Fundamental
звернули
Values
увагу,
in
що
Digital
неодноразово
Era.
отримували листи.
Probably when
Була
you
така
received your
оговірочка
invitation
зроблена, що
letters, you
ця
noticed a small
панел-дискусія
disclaimer
реалізується саме в
that
рамках
this
цього
panel
проекту.
discussion is
Ну і, власне
implemented as part
кажучи,
of this
ми
project.
багато про нього розповідали і
So
попередні
we have
рази, але
talked a
сьогодні
lot
я би
during this
хотіла
project
поділитися
previous
певними
time,
такими,
but
знаєте,
today I
слайдами,
also
даними
wanted
стосовно
to
нашого
share
цього
some
проекту.
insights
Цей проект
regarding this
був
project.
започаткований у
This project
2022 році,
was
1
started in
листопада, і в
2022
цьому
on
році, 1
November
листопада
1st, and
2025
this year,
року,
on
він,
November
на жаль,
1st,
добігає свого
2025,
кінця.
it
Тобто
will
ми всі свої
unfortunately
активності вже
end. So,
виконали і
all our
будемо
activities
звітувати
are
перед Європейським
completed,
Союзом
and we are
про
about to
стан і
report
якість
before European
їхнього
Union
виконання.
regarding the status and
Але
quality of
цікавою була
implementation.
історія, як з'явився взагалі цей проект.
But actually, how this project
Проект цей
started? It's
був
an interesting story
ініційований
indeed.
іще на
This
початку
project was
2022
initiated
року.
back in the
Коли
beginning
кілька
of
подумки про те, що
2022,
може
when
розпочатися
there
велика
were
війна.
nothing but rumors
Але,
about big
граючи на
large
ці
war in the
чутки,
country.
ми не особливо
But
їм
despite
вірили
this,
разом з
despite these
учасниками
rumors,
нашого
we
проєкту
didn't
і
believe it along with
відверто
other
продовжували
participants of our
працювати
project,
над грантовою
and we
заявкою
continued to
для
develop our
цього
grant
проєкту.
proposal
Працювали,
for
а хто
participation. We
подавав
worked on it,
заявки на Erasmus, ті знають, що
and
це
those
дуже
who
складна і
at least
кропітка
once
робота.
applied with
Ну і,
Rasmus
власне
know that
кажучи,
preparing
ми
a
її
drafting a
виконували
proposal
всі
is very
разом. Було
complicated
задіяно
and
кілька
challenging work.
учасників. Це
We
і
worked
я,
all
і моя
together, we
коліга
engaged several
Розмітаєва, і
participants,
наша
me,
шановна
Ms.
колега
Razmitaeva,
Олена
and
Уварова
our dear
також, і
colleague
багато
Olena
інших.
Uvarova
І всі
also
дуже хотіли,
participated,
щоб заявка
and
наша
everyone
була
really hoped that
максимально
our
така, знаєте,
proposal
дійсно якісна.
would be
І ось
really high
починається війна
quality. Then the war
24
broke out.
лютого
On
2022
February
року.
24th,
А дедлайн
2022,
для подачі заявок
while
28
the
лютого
deadline for proposal
2022 року.
submission
Ну
was
і, власне
February
кажучи,
28th,
я пам'ятаю, як я
2022.
дзвоню нашій колезі
And I
Олені
remember
Уваровій і кажу:
I
ну,
made a
що
call to
робимо?
a colleague,
Катастрофа
Novarova,
відбулася,
and what are we going to do?
відбуваються
Probably
якісь
we shouldn't
жахіття.
apply
На що
because
вона
terrible things
відповідає:
happened.
ну,
And she,
розумієш,
and
я
she
бачу,
responds to me,
що
you
прориваються
know,
російські танки десь
I
десь
see
в дільниці,
Russian
я з балкона
tanks
це бачу.
uh,
Але,
from my
здається, наші
window
їх
on
уже
the next
відтісняють.
street, but
Тож у
seems
мене ще
like
є
our
пару
military
годин
of
по
sea
заявку. І
to
вона цю
actually
заявку
apply.
подає.
And she
І
applied.
тому для
She
нас
submitted the
цей
proposal.
проєкт
So, you know,
є дуже
this project
таким,
for us
знаєте, я би сказала, з відтінком певної сентиментальності
is a
і
bit
певних таких,
sentimental
знаєте, емоцій
and very emotional.
різноманітних. Як
We
написала
have so
нам
many
наша
emotions
колега
mixed up
із
around
Кіпру,
it.
вона сьогодні
Our
теж
colleague
буде
from Cyprus,
виступати, пані Стефані,
who's
вона
about to speak
написала
today, Miss Stephanie,
The fact
wrote me
that
a
you
message.
have successfully submitted this application is a victory in itself. І ці слова закарбувалися в пам'яті дуже
And
сильно. Той
I
факт,
have
що
really
ви подали
remembered
цю
these words.
заявку,
The fact is
а
that you
ще не
submitted
знаючи,
this
виграєте
application
ви чи не
itself
виграєте
without even
цей
knowing
проєкт,
are you
є
going to be
перемогою
awarded or
самою по
not
собі.
is a
І
victory.
ми перемогли. І
And
нам
we
дійсно
prevailed.
Європейський
Yes,
Союз
we
дозволив
won.
проводити цей
European
проєкт і це
Union
дослідження.
supported this
І це
project,
дуже для нас
supported this
цінно.
research, and it's really
Я зараз
meaningful and
виведу на
important for
екран,
us.
знаєте, такий,
Now,
скажімо так,
I will
агрегатор
share on a
досягнень
screen
наших по
a
цьому
kind of a brief
проєкту.
overview of
Це
our
сайт, який ми
aggregated
нещодавно,
achievements under our
можна
project.
сказати, що завершили,
And it's a site,
але
it's something.
максимально наповнили. І на цьому сайті,
This
от
is
ви
a website.
бачите,
It's not yet finished, but it's already full of content.
EFVDE.org.ua,
So you
це
see
скорочено European Fundamental Values in
EFVDE
Digital Era.
org.ua,
І ви
European
бачите
Fundamental
на цьому
Values in
сайті, тут є
Digital
декілька
Era.
рубрик, тут є
Here
декілька
you see
мовних версій,
several
і тут, власне кажучи,
sections,
буде
several
більш
language
докуп
versions, and
наша
collection of our
команда. Тут всі
achievements.
такі
Here
красиві.
you see our team.
Подумаєш,
We
що
are
ми
so
тут, значить, в
beautiful.
стані війни
So
живемо.
when you look at these
От,
pictures, you can
але
believe
все
we
нормально.
really live amidst the war.
Тут
But this is our
є,
team.
значить, опис
Here we have our
проєкту,
project
такий
outline,
коротенький розділ, який
description.
присвячений
We
нашій
have a research
дослідницькій
activity
діяльності.
section.
Зокрема, ми встигли за цей проєкт написати багато
Also,
статей,
during
порядку
the
15.
period of
Вони
this
всі
project,
виставлені
we
тут.
wrote around
Також
15
тут у
papers.
нас
They are
є
all available here.
монографія
We also have a
англійською та
monography
російською мовою,
in
написана
English and
якраз
Ukrainian language,
присвячена європейським
which is
фундаментам
about
цінностям
European
цифрових.
fundamental
Тож в
values
розділі
in
Research
digital
Activity або
era,
дослідницька
and
діяльність
you can
управління
find it in
EACEA можете
research activity section
ознайомитися
of
із
our website.
цією
So
монографією.
please
Вона
feel
в
free to
відкритому
read it.
доступі
It's available
і
in open
повністю
access
безкоштовна.
and absolutely
Також
free
у
of
нас
charge.
тут є всякі заходи, які ми
We also
проводили
have various
в цьому
project
проєкті.
events.
Це і
So
воркшопи
events
для
we did as part
студентів,
of
і
this
воркшопи для
project,
практиків.
workshops for
Тут є
students,
посилання на
workshops for
YouTube,
the YouTube
і все
channel. We
дуже
once again are so pretty
оформлено,
and
принаймні
everything
гарно.
looks
Але і по
so
контенту,
nice
по змісту
on the
всі ці
website at
заходи
least.
ви
But thanks to our wonderful
Отож,
experts Grishko. He is managing director of Sergei Grishko law firm, Queritus Ukraine. He has over 18 years of professional experience in representation and counseling at all stages of negotiations, litigations, international commercial arbitration, international investment arbitration, post-judicial and post-arbitration planning, enforcement proceedings. He took part in many arbitration proceedings under various international, institutional, and special arbitration rules, including Ukrainian Chamber of Commerce and Industry, and other arbitration courts, even under UN Commission on International Trade. European Commission has registered Mr. Grishko in a list of candidates for appointment to the position of the head of arbitration court head, presiding arbiter, and he will present his and he will tell us about prospects of further implementation of online proceedings in Ukraine. And another small disclaimer. Given the fact that we have simultaneous interpretation, I will kindly ask each of us speaker not to rush and speak a little bit slower, so our interpreters have enough time to interpret our complex and confusing legal nuances. So please, the floor is yours. Yes, sure. Miss Natalia, thank you so much for this opportunity. Thank you for introducing me. I'm really honored to participate in ninth Kharkiv Legal Forum. I'm happy to see our colleagues, familiar faces, and people I don't yet know. So I hope today we will have a really fruitful discussion, and we will discuss and we will have a chance to reflect on very important and relevant challenges Ukrainian judiciary is facing right now. So, do you have my slides? Yes. Let's try to change slides, because sometimes we have a problem with it. Okay. Give me a second. Is it changing? Yes, amazing. So, today, the topic of my presentation is the prospects of online proceedings implementation in Ukraine, and here I have three large sections I want to discuss today. Basically, it's a kind of audit, inventory check of Unified Court Information Telecommunication System. So the name was changed in March 2024. I want to talk about its achievements and status quo, then about the relevance of remote proceedings outside of court buildings and extraterritorial online proceedings. So let us start.
Before 2017, some elements of the general court jurisdiction started to be applied. Started using some IT elements such as automatization of documents turnover and software, special software since 2004. In some courts, technical tools started to be applied, but already starting since 2010, this practice became widespread. Then there was a possibility to have a unified register of court decisions. And I think that it's a unique precedent because not all countries have a system which is similar to our united register of court decisions since 2010. The automatic assigning of cases to courts has been started, and 2012 video recording of conferences started to be applied in courtrooms, and since 2020 participants to the cases also were able and had an opportunity to record meetings using their own software and their own technical tools. That's historical retrospective. The law 2147 dated 3rd October 2015 envisaged implementation in courts, High Council of Justice, High Qualification Commission of Judges, State Judicial Administration, Service of Judiciary Guard, use unified court system. So it means that starting 1st December 2015, State Judicial Administration, using the portal of the Judiciary of Ukraine and in the newspaper Voice of Ukraine, placed an announcement of the High Council of Justice about start and launch of functioning of the unified electronic communication system. Short abbreviation is EACEA, but only 4 months it had worked, and then there was a disruption, there was a problem, and for more than a month a lot of services were unavailable for clients. So it became clear for us that we were in a hurry and the system was not functioning as it should be, and so it means that that in a month, the High Council of Justice cancelled that announcement in the newspaper and the web portal, and there were some piloting elements to research and to test them, and then electronic account was used, but it was also absolutely clear that it's impossible to launch the whole system as it is, offering all the elements for clients. On the 27th April 2021, the law 1416 was adopted. The law on making amendments to some normative acts of Ukraine on ensuring gradual implementation of the EACEA. Since 5th October 2021, officially there are 3 functioning subsystems or modules. It's electronic account, electronic court, and subsystem of video conference. Despite of the fact that there are definitely some drawbacks and everything is functioning as it should be, anyway, it simplifies significantly the work. As a lawyer, from my practical perspective, I could confirm that from client perspective, from user perspective, it's not an optimal system. Since 2004, registration of an account in EACEA became obligatory for different specialists in legal sector, such as representatives, local government authorities, experts, public agencies, government bodies, private enforcement officers, notaries, lawyers, and so on. Since 21st February 2024, such registration also became obligatory for legal entities of private law who are parties to the civil and administrative cases. Individuals are not obligatory, are not obliged to register accounts there. Hence, in 2023-2024, there was a technical and financial audit carried out of the system, and the outcomes of the audit was the following: that's a technical outdated system which has unfeasible architecture and which is functionally limited. In the EACEA concept, key drawbacks are mentioned. This concept was issued and approved by the State Judicial Administration order dated April 2024. So this order author says that this system is not the only system, it's not a system as it is, but rather it's accumulation of different modules or elements which were built in different times and which use different types of technologies. Information exchange between available subsystems of the system doesn't always work as it should work. And the findings are the following, that it's not feasible and appropriate to improve available subsystems, and it's suggested to implement unified centralized solution which will ensure integrated environment for implementation of necessary functions. And modernized system will allow to ensure usage and reusage of available services, functional components, and other data. As you know, you don't have a unified system which will allow general search of data for now. You need to go into different modules and submodules looking for different core decisions and so on. So what are the plans for the future? A roadmap of development of IT solutions in judiciary system and this EACEA concept were developed, and it was decided to create to develop a new EACEA system, so unified telecommunication system, which will replace the old one, and it should be done by 2028, and this process shall consist of two stages. So the first stage, that's this year and year 2026, it's to complete already started, initiated EACEA development projects, and during this project, during this stage, to ensure development and implementation of key functionality of subsystem of electronic document turnover of courts and other subsystems and subcomponents. During the second stage, it's envisaged to improve and finalize additional and experimental parts of the system functioning, and also some of those functions will be delegated to the artificial intelligence. So it was a plan, but as you know, and everyone who works with grants or just read news know very well that after January 2025, when the new president of the United States of America started working, and EACEA function was suspended, along with support of EACEA to organizations in different countries. As a result, all projects were suspended, and all fundings to the projects were suspended, including EACEA functioning in Ukraine. It led to complete stop of work of this support from the EACEA side, and it led also to the following fact that just a few weeks ago, on 11th September of this year, the High Council of Justice published an official application to the Ministry of Finance and Cabinet of Ministers, saying the following, that it's not envisaged for the next year to fund functioning of the unified telecommunication system. And right now, modernization of the system is under huge risk because the EACEA stopped functioning. There is a continuing search for donors, but there are no available donors. And the Ministry of Finance, in response, also replied that the judiciary authorities and bodies shall strive for optimal quality and optimal implementation using limited resources. So that was quite a formal reply, saying nothing about anything. So let's move to the second part of my presentation. That's fully remote court hearings beyond the premises of courts. So since 24th February 2022, and And till now, 170 premises of 161 judicial facilities were damaged to different extent or were subjected to damage, destroyal, or embezzlement of the property. And we all remember very well a missile attack which took place on 29 March 2022 when commercial court of Mykolaiv region was fully destroyed and two court staff persons were killed because of this missile attack. There was another attack which also led to complete destroyal of premises and death of people. And on the fourth year of our war, we still have a problem that procedural legislation doesn't envisage fully remote court hearings. Procedural code doesn't envisage yet any opportunity for participation in a court hearing for participants to the process and parties to the process who cannot stay in the premises of the court for that moment. And the list of such persons includes courts, secretaries of the court hearing, witnesses, interpreters, specialists, and experts. So I would tell you my own experience. I participated in the court hearing of the British court. So this court hearing was fully online. It was in Skype. So Zoom didn't exist at this moment. So what I was impressed with that the judge was sitting somewhere at their house near the fireplace, listening to the court hearing. It's 5 years ago. Unfortunately, this luxury is not allowed for our judges. So there were some attempts to make amendments to our legislation regarding an option for a secretary, witness, and interpreter, and other specialists to participate in a court hearing remotely using their own IT solutions. The attempt was made with a draft law 8358 in 2023, but it was but it was just taken out from consideration. So that was there was another draft law which is very similar and to the draft law mentioned before. So the numbers of the draft laws are two: 7316 dated 26 April 2022 and 8358 dated 13 January 2023. But both attempts failed and they were not adopted. The draft laws 9090, 9091 as of 10th March 2023 envisage that court hearings can take place remotely, can take place using video conference tools and beyond the premises of a court during the martial law under circumstances which bring health and safety of a judge, participants to court processes under risk. But there is a huge but. So if there are technical opportunities, if there are available technical opportunities to consider cases in electronic form, and a judge, secretary of a court hearing shall take place in such hearings from the government-controlled territories of Ukraine. But on 17th July 2025, this project was lifted from consideration. Somehow, even despite of the fact that this draft law was submitted on the initiative of the government, but the government failed to submit this draft law for second consideration. A report of the European Commission of the Ukraine for 2023 says the following: in light of the difficulties caused by the war, including relocation of population and businesses, deterioration deterioration of economic situation and decrease of security, deterioration of security conditions, Ukraine shall adopt a legislation which will officially put everything in order, including in different circumstances, including emergency circumstances and war circumstances. Analysis of the European Commission on the issues of effective justice and the project of Council of Europe support of judiciary in Ukraine for ensuring better access to justice as of October 2022 says the following: the issue of remote or physical participation of a judge in judicial proceedings is both political and a legal issue, and there should be a roadmap on the issues of the rule of law, and it shall be developed till specific deadline, but it's not yet done. Just recently, Ministry of Justice published a joint research carried out with EBRD regarding possibility of regarding legal aspects of flexible territorial jurisdiction, comparative and constitutional analysis. So the key task is to ensure equal workload on different courts located in different regions and to ensure rights of citizens to fair trial. So it's not a secret that the workload is so different depending on the region. For example, Kiev courts have a so high workload. Also, courts located near the front line under huge workload, but at the same time, in the west of Ukraine, there are so many courts which workload is not that high. So there's a critical perspective on the issue of territorial jurisdiction and how to ensure actually practical accessibility to courts. Why do we have such jurisdiction rules? Why do we apply for specific courts rather than to any court which we would like? So there should be a practical accessibility to a judge, to a court. There should be a relevant distance between participants to the court proceedings and judges, and so on. So it all has logic. And actually, it works very well when there is no organizational access to a court. So what are the findings? Legislation shall correspond to requirements regarding access to justice and fair trial and shall not create excessive obstacles for all parties to the proceedings. And at the same time, an opportunity to submit documents and familiarize yourself with case files shall not be violated because everything will be registered in one and the same unified telecommunication system. So how such extraterritorial jurisdiction shall work? An opportunity to be present in court proceedings, it's one of the aspects of access to justice, and very often extraterritorial jurisdiction doesn't impact on opportunity of parties to be present at court hearings because cases according to the draft law, cases shall be considered according to such extraterritorial jurisdiction usually do not require participation in offline court hearings. And there are some other reasoning and justification behind it. I also shared some best experience of other countries, for example, Croatia, France, Germany, Italy, Netherlands. They have an option to choose the place of consideration of case upon agreement. Also, one court which corresponds to consideration of all cases of under specific categories. That's a practice of Estonia, Germany, Greece, Poland, Slovenia, and some other examples and practices of other countries. And actually, our Ministry of Justice right now is considering accidental assigning of cases across different regions and across the country. In 2023, Bulgaria has made radical amendments to Civil Procedural Code of Ukraine, reviewing territorial jurisdiction of courts in cases on ordered proceedings. And according to Bulgaria case, the assignment of cases shall be based on algorithm focused on equal workload of all courts. So it means that if a court has a lower workload, it will receive more assignments. In Croatia, in 2015, they introduced universal territorial jurisdiction regarding courts of second instance. These are precinct courts, and complaints and challenging of decisions of courts of first instance shall be considered in different courts, and assignment of cases shall be done not intentionally but by accidental algorithm, and in such a process workload of different judges and different courts should be taken into account. And that will also help to lead to decrease any possible local interference in different courts across the country when we speak about challenging the decisions of the court of first instance.
As long as I know, Croatia does not standardize procedure for organization of such hearings. However, online format seems to be optimal. So what is the concept of the Ministry of Justice? To introduce a mechanism to ensure balanced distribution of cases between judges and courts of the first instance, to ensure their effective adjudication. The draft law provides for cross-jurisdictional online hearing for certain categories of civil and commercial cases at the first instance level. What does it mean? Basically, this is the random distribution of cases among judges, which happens not among the judges of one court like now, but among all judges included in the register based on algorithms to identify the caseload coefficient of every judge, and the cases subject to such cross-jurisdictional consideration are so-called minor cases in the meaning of the procedural code, cases arising from employment relationships, cases related to temporary exit of the Ukrainian territory by a child. So parties to the case considered in cross-jurisdictional proceedings may join the court hearing using video conference link from outside of court buildings. The procedure for contestation remains unchanged, so through the Court of Appeal at the location of the initial court, and this draft law changes territorial jurisdiction rules for first instance cases to address unbalanced caseload, expedite the administration of justice, and provide courts with higher flexibility in managing the national challenges. Obviously, that it has been relevant for a while, and it will ensure access to justice in smaller communities, take into account administrative territorial reform in Ukraine. It will allow to maintain the existing court network without elimination of local courts due to reduction of the number of districts in the country, and it will also expedite the administration of justice, because currently in Ukraine sometimes it takes many years for adjudication of civil cases. And such changes are also in line with Ukraine's international commitment under European Convention on Human Rights and the Fundamental Freedoms that don't create barriers in access to justice and allow to support legitimate goals, increasing the autonomy of parties, increasing procedural convenience, and it will promote judicial specialization, operational efficiency, and effective response to temporary institutional challenges, which is the high accumulated number of cases and unbalanced caseload of the courts. So thank you so much for your attention, and I will be pleased to answer your questions. Thank you so much, colleagues. Thank you, Mr. Sergey, for your very exciting and detailed presentation about digital justice. Dear colleagues, do you have any questions to our speaker? Mr. Tena, please. Hello, dear colleagues. Mr. Sergey, thank you so much for your amazing presentation. But there are several questions I want to ask. Given the name of our today's event, of our today's discussion, you mentioned it a little bit, a right to fair trial and the right to access to a court. I have two questions. My first question is more value-driven. Don't you think that remote proceedings and extraterritorial jurisdiction providing for online consideration of cases. So don't you think it violates the guarantee of publicity? I mean publicity for general public. Because if the rights of parties are ensured in online proceedings, and there are even European Court of Human Rights considers online format as alternative for case consideration in exclusive conditions. For example, when a person is kept in custody and has no other option, pathway mechanism to participate in civil cases, there are some specific opinions of the European Court of Human Rights on participation of parties. But I have a question regarding public interest. I mean public hearings, open hearings, in particular the European Convention and Procedural Code of Ukraine directly lists the cases where court hearings is held in closed format, in closed hearing, while otherwise we need to ensure publicity for the nation. And so how to address it? And secondly, it's more pragmatic and more technical. If we change the jurisdictional rules and introduce extraterritorial jurisdiction only for courts of the first instance in suggested categories of cases, here we have two issues. We can balance the case law for first instance court, but then if case goes somewhere to Ternopil, and I have to consider the petition of appeal in Ternopil, isn't it going to result to overwhelming caseload of unbalanced caseloads of the courts of appeal, and doesn't even make sense in this case to opt for this extraterritorial jurisdiction, this rule, given the fact that my case will go somewhere and then it will just follow the general instance jurisdiction rules and simplified and so, as for orders, I have no questions. The court just delivers an order, and if the borrower does not agree, they may just submit a petition against it. But simplified adversarial proceedings sometimes may, so simplified claim proceedings sometimes may transformed into general proceedings. First, we believe it's gonna be simplified, but then parties do their submissions or third party emerges, and it's not simplified, and it's not simplified proceedings no longer. It just becomes a general procedure. Mr. Tiana, thank you so much for your amazing questions. And as part of my within my competence, I will do my best to respond to it. First of all, about publicity of process. It's extremely essential guarantee. I believe it's more a technical rather than legal challenge, because everything will depend on practical implementation of this new system. In my practice, I had some cases of extreme social interest. They were not heard online. These cases were heard in physical court hearing, but they were broadcasted on a YouTube channel. So, provide appropriate technical implementation of this remote online proceeding system, the publicity will be even better. Because so how does it work now? Everyone knows it. You're supposed to know the date of the hearing, you need to go to court, you need to wait in line, you need to find a proper room, whether the hearing is in a church or office. You need to know it. But if it's properly implemented technically, if I can simply Well, click a button on a YouTube channel, open a YouTube channel of relevant court, and watch the broadcast of the hearing. It will significantly facilitate exercise of my right to publicity. It will be much better than what we have right now. Your second question. I actually have the same question to the Ministry of Justice, so probably following our today's discussion, probably we will have to prepare a joint letter. I don't know whether it's practiced at Kharkiv Legal Forum, but I think it would be good to prepare a joint letter and highlight for the Ministry of Justice that you can fix one thing, but there are other, but it won't change the whole system. We need to make sure that we have similar system both for first instance and for appellate instance. The only barrier here is our beliefs and perceptions. Like it says this is court X, then it's court X. Because, well, we have digital courts, we have digital case files, so it doesn't really matter if it's the court. It doesn't really matter if the first instance court is in Chernobyl region and appellate court is in Sumy region, because both courts will have absolutely equal access to case files. And it's pretty absolutely agree with you. Then your third question. Minor case, and soon, but later, it ceases to be so, and we need to somehow regulate it. The Ministry of Justice has not provided for it in its draft law, so probably we should once again bring attention of the Ministry of Justice to this aspect, the need to turn these situations. They definitely will emerge, I'm pretty sure about it, so once again, thank you so much for your very specific and really important, really very practical questions. Thank you. Thank you so much, Ms. Tatiana, for your interesting and very meaningful questions. And thank you, Mr. Sergey, for your very insightful and detailed responses. Any other questions, dear participants? Any other questions for our presenter? I don't see any questions yet. And I don't, unfortunately, think we don't have much time for more questions because we're a little bit behind our schedule. I actually wanted to ask a question, but this question is a bit off top, not really related to your presentation, but still related to digital justice. And it will be a small bridge to the topic of artificial intelligence, and the topic to be presented by our next speaker. So my question, recently there is Mr. Dmitro Dubilet, famous Ukrainian digital entrepreneur, announced a new project. He is going to initiate full substitution of judiciary, modern judiciary with artificial intelligence to overcome bureaucratic challenges and corruption issues. Well, it's just an idea for now, but this idea was voiced not just by a regular citizen, not by just some pioneer engineer. It's quite influential person in Ukrainian society. We're not going to reflect on it in the context of Mr. Grishko's presentation, but let's use my question as a bridge to the topic of artificial intelligence, and now I will give floor to our next speaker.
Our colleague from Lithuania, Gintare, Dr. Gintare Skaite Samuole is an international law researcher at Mykolas Romeris University, Lithuania, as well as a practitioner working in digital services. She is interested in technology regulation, focusing on transparency and the right to know. And I should say that Dr. Gintare always participates at our panel discussions, and her speeches are really brilliant. And she tackles all these the most topical issues concerning an AI and other modern technologies and law. And I should say that her speeches are always very in-depth, very detailed and full-fledged. So they all cover most of the issues which arise in practice and may arise in future. And these future issues, in fact, are our concerns today because of these technologies. So the topic which Dr. Gintare is going to represent today is AI in practice, from legal summaries to medical advice and their impact on human rights. And maybe Dr. Gintare also will cover some issues concerning AI and justice. Who knows? So maybe we will talk about it a bit later. So the floor is yours, Gintare. I'm really glad to see you today with us.
Thank you, dear Natalia. Thank you, dear colleagues and dear participants. Thank you very much for the invitation to speak in the conference and listen to the outstanding presentations of others. So I hope that my presentation today will be beneficial for further debates, and I will satisfy these high expectations that Natalia just talked about. And my goal today is not to be a very theoretical. Instead, I will share the practical perspective from media industry to the view of media companies that act in different roles. They act as both AI users, deployers, providers, and also public, and what is the role of human rights in AI ecosystem when EU AI Act is already in force, and then what are practical insights and needs to calibrate these human rights. I, of course, will not be able to cover all aspects, but only some of them, because time is a limiting factor. So I will actually focus on two different layers. On reactive level, how the media sector is changing both externally and internally in global conditions, intellectual property, and so on. And then I will speak about proactive level. Then media sector is creating AI, and what is the place of human rights in this process when you are on the different side of the barricade. So let me begin and start with the reactive side. And with the reactive side, we have two dimensions, as I've already mentioned. Europe is not currently the pioneering leader in large language models. We see today that it's not the EU that has most of most popular models and so on. And there are also other changes, both tectonic changes in the attitude towards rule of law, tectonic changes in geopolitics, tectonic changes in technology. So we all are working in quite dynamic and unstable circumstances, and sometimes you cannot do many things about it. So you have to adapt to it. So the rules have changed for the media sector due to this, and then the media has to navigate in limiting conditions. If we look back for 20 or more years, it was clear for the media that it creates like journalistic articles, communicates with the public. It was clear that we follow the usual line. It's the humans that search for information, and then media has to think as humans and make the information, their opinions, findable and clickable. So it was quite clear based on SEO, and then it was a direct link between media and the public. You just make a good research on politics, you publish the article, you make it findable and clickable, and then you reach the public and act direct as a public watchdog. From the other side, we see that we have structural changes to content publisher market as well. It also changes. We see from statistical surveys that AI strengthens big tech itself because they integrate services. They want to integrate AI as a universal tool everywhere, and it means that they will control both content supply and distribution to users at the same time. So here we have the problem of self-preferencing. Then we have, let's say, variant of the same service to that is towards customers. It is the best result. But if we look into the same model that is provided for businesses, it is more raw. So we can see the actual comparison of quality, let's say, of OpenAI and Copilot and ChatGPT. They use the same raw foundation, but the result is different. So if we look into the ICJ practice, we saw in case of Google that self-preferencing was found abusive and a platform favored its own services. So there is one problem. Then the second one, we see from statistical surveys that big content publishers are more cited in generative AI answers. So it seems that then it will change the media sector as well. The big ones, the big publishers will flourish. Then the smallest ones, the niche ones, that have very specialized information, they also will find their audience and their way to navigate. But what about the medium ones? In case of Europe, that is often characterized with regionality, with state, language, with diversity, that does not have many big publishers in a global sense. It is very important. The good news are that they also can use open small models, but they might be not comparable in the global sense, and the digital divide might deepen. And further, we have intellectual property challenges as well. We know that AI uses massive data sets to train data. Data is the new fuel, and the means to scrape the information are actually very widely available as plugins to any person. So now we also see that training at the moment is even more important to get quality in contrast to initial scraping. So again, we have a worldwide West situation when different options coexist at the same time. Some buy information, pro content, so we have licensing deals. Some steal. We have illegal scraping. We have non-compliance with robots.txt that jumped from 3% to almost 14% in a quarter. Some recreate. We also saw situations when there was paywalled content that was rebuilt from secondary mentions in social media or in archives. So you cannot pay a technical wall to that. So the legal question would be, should we rethink the data mining exception in copyright directive that is with opt-out mechanism, because they were better designed for small-scale academic research and not industrial AI training. So maybe a certain licensing scheme for training data similar to collective management in music might help. We saw technical solutions such as Cloudflare that already design some protections, but again, it's too early to talk about the efficiency about them. Of course, it would require a negotiation, a significant negotiation at EU level. But we also see that big tech is dictating their terms as either you do it all or you get nothing. For example, they actually integrated their services that much that, for example, you cannot opt out just from AI overviews and be just with indexing. And then the other thing, you actually cannot prove if the bots that came, if they indexed just the titles or took the text as well. The fourth thing is the changing user behavior. We have quite clear risks with AI-driven personalization. The actual, we can make an analogy. Some of those who have children know how the Snapchat filters act on selfies and so on. So the AI now may act as a Snapchat filter to not only on photos, but on information as well. If you want to beautify something, some information, we will get a beautified something. But the risks with beautified information are much bigger than beautified selfies, including expression, information discrimination, bias, security, and other concerns. We have information bubbles that narrow perspectives. We have deep fakes that blur the boundary between reality and fiction, and also platforms that merge personal data with browsing. They buy browsers, leading to a very wide type of surveillance. So legally, there are measures like GDPR principles of fairness, transparency, minimization. We have systemic risk assessments for online platforms under Digital Services Act. But are they actually enough? Maybe we should give more to users, more control to users, and not to keep them passive ones in a passive roles. No blind type personalization. We should give personalization management options, alternatives, recurrent user approvals that would help to ensure digital identity in control of a physical person, in that hands of the owner of that digital identity. And then the fifth thing that is also important globally, we see that we have doubling of AI bot traffic that disrupts advertisement business logic, and then it may blow the information overload even more. So if we have like 3/4 of online content is fake or very low quality, this again triggers consumer protection and misinformation concerns. And if there is an explosion of irrelevant and false AI-generated data, then we have problem of digital waste that is similar to environmental waste, but just in informational sphere. So again, it might require new legislative frameworks to be developed that would call for responsible data management, responsible AI publishing, including traceability, and also the competition angle. If the truthful information becomes harder to find, then the dominant platforms that control filtering could also be able to gain even more market power. And now I will continue with internal reactive challenges. Then organizations as media organizations as AI deployers encounter when using AI. So what happens internally within these media organizations? So the first thing is with trust. Well, generative AI access is so democratized. Without clear policies, employees often act independently, creating legal gray zones under GDPR and the AI Act. So we also know from researches that there are high trust states and low trust general political trust states. The Eastern Europe usually falls into low trust states. So we see that adoption then depends on strict rules of enforcement. And then the companies also focus more on compliance rather on innovation. And then they might be inspired to develop products that more about control, about surveillance, because it's within the character of these states. Of course, the lack of trust may signal a lack of fairness and openness in the organizational level that might differ from state level. At the same time, AI promises productivity, but floods employees with low quality data that again result of rushed decisions, mistakes, and even court claims. We have court claims for barristers that used AI content for writing claims and did not check the sources, and then we got court cases, disciplinary court cases about that. So fear of job loss, AI will steal jobs, then it means that the employees start to use AI secretly with unapproved tools and data leaks. But again, I will not exaggerate. it is the employees, the lowest level that act today as human rights safeguards, as shields, because they are already trained and competent in the human right area. They know, they use traditional things. They know about the traditional human rights. So they serve as last line of defense against AI error, as they have competence, experience to notice what is wrong, and they are responsible for the final result. But while GDPR and cybersecurity extend all these rules, we can't stretch these rules to cover responsibility in the sense of data protection and then the data protection officers and cybersecurity officers have this responsibility. These roles cannot fully cover AI systemic risks, especially with personalized digital twins amplifying privacy and discrimination concerns. So companies now rely on traditional human right understanding to manage AI's impact, but this framework is too narrow for digital or emerging rights or cross-border AI risks. And of course, the situation is worse because of geopolitical tensions and global attitude to human rights and delayed EU guidance. Then the media businesses are in slower, safer AI adoption. If we look culturally to the statistics again, we see that AI adoption moves faster than we have organizations or certain departments within them that are younger, that are larger, that are more professional, that are highly digitalized. And those groups, they adapt quickly, they scale, they absorb risks, while we have also older, smaller, or less digitalized teams that lag behind, that struggle with legacy systems, with resistance to change and compliance barriers. So it is good for the big and quick. These are competitive ones, but there are sectors that are not characterized in the same way, and then we might have a deepening digital divide. Locally, also, there are organizational campaigns to raise competence, and we have awareness campaigns, trainings, and the easiest way to get the adoption is to integrate AI into workflows that already exist. So if Microsoft Office is very popular, then it is very logical to put AI in the usual workflows where for the AI to be findable and usable. But again, it has its own cost because we have AI ecosystem and informational exchange and hidden risks from data leaks to biased outputs. It is clear that even if we have AI agents that grow more autonomous, organizations at the moment still prefer human-in-the-loop model to keep accountability and reduce that legal exposure. And now I will continue with the last part from the creator side. So what happens if we switch roles and the media business then starts to create AI itself? So do we have then double standards and different attitude to human rights then? So it is clear that there is a shift towards more open AI models compared to closed one that is driven because of a competition with Chinese alternatives, and focus on smaller language models that are that are cheaper to adopt and that are easier to adopt. And we see that OpenAI already released its first open models. And here we have both advantages and disadvantages. It is good that they are here. We might develop small niche models and create new things and greater transparency. But then we have to invest more to security, as again, these models often fall behind the standard rules for general purpose AI systems. So systemic risks might be for long and come unnoticed. So the critical question in here that rises usually locally, so how to test this, if the small model is human rights compliant, how to foresee future risk management mechanism, how to be compliant, are there any soft law or like guidance or questionnaires? Is there any kind of blacklisting of bad models that come from, for example, from unfriendly states? Now we do not have as clarity. We have to work on it, and the risks are not necessarily calculated at the moment, as the choice of model is an exploitation regime, and then IT decide what is good, and IT persons are not necessarily the best persons to evaluate things in the human rights perspective. Then the other thing is the choice of models.
Gintara, I'm sorry.
Yes.
I'm sorry to interrupt you. I'm afraid that we are running out of time a bit. So could you please make the conclusions? Okay.
I've talked about that. Just to mention that we have high-risk AI systems and gray area in that, and delayed adoption. Then businesses are try to manipulate potential gaps within EU AI Act. From practical use cases, we see media develops everything from chatbots, agents, workflows, synthetic podcast, news aggregation, assistance, chatbots, so everything that's possible. But what is clear again, that we cannot answer all questions. Let's take synthetic podcasts. For example, if we have this, then how human-like the voice should be, and then if me myself, I clone my voice for using it for synthetic podcast, and then I have a question for myself: what if this data will be leaked and my voice will be used for fraud reasons, to call my mother, to cheat about money, and so on? So all these questions are you take the risks, but you take the risks at the cost of human rights. So my last thing that I wanted to say, that we already have an outstanding work with digital acquis, but laws against are not sufficient. And we'll have the questions of enforcement and judicial interpretations. So the last question would be, will the courts rise to the challenge to shape AI constitutionalism, or will regulation remain in passive and reactive mode? So I will leave that unanswered, and thank you very much for your attention. If you have questions, I will be happy to answer them.
Thank you so much, dear Gintare. Your speech is, as always, very, very detailed and very, very interesting and up to date. So maybe our listeners have some questions to our speaker. While you are thinking about your questions, I will ask my question, okay? As I am a researcher in the area of private law and in particular in the area of IP law, I want to ask a question concerning IP, intellectual property. So I recently read an article that AI technologies will shape copyright so much that copyright will protect not the outputs, not the works, themselves, because works very soon will be generated mostly by AI systems, not by humans. And copyright, in the end, will protect prompts which human beings enter into ChatGPT or whatever to have some work generated. So I saw at your slides, I think it was the third or the fourth slide, where you mentioned that there is a shift from human clickable content to machine readable content, right? I think that my question is in line with what you have said. So do you think that AI will challenge IP and copyright in particular that much that we will stop protecting the works themselves and we will protect only prompts? Thank you.
Thank you, dear Natalie. It's a very, very good question and very future oriented. So I cannot say what will happen about like 100 years after today. But for the moment, it's clear again that there is opinion that copyright should protect prompts as it's like a commercial thing, like property. You don't want to share with everyone, as again it might produce a different thing, and you give you make it quite of competitive value to get this one. But I could not imagine that the copyright would change that much, that we will not use our understanding that is today to copyright, and that the works will not be protected, just the birth ideas of these works. So I at the moment, given my experience, I think that it is too early to be afraid of that. Maybe later on, we don't know what will happen later. Maybe our understanding will change. But now I think that there are classical things, traditional values that will still be in place, and it will not be like a revolution that will undermine everything we know about copyright.
Thank you so much. Me too. I don't think that it will happen in the short run, but maybe in the long run, we will see. Thank you so much. Чи є якісь питання до пані Гінтари від наших
So,
слухачів?
any other questions to Ms. Gintare from our listeners?
Okay. Victoria.
Oh, I see Miss Victoria, please.
Hello. I've seen a slide about rights of employees. So I have one little question. Lately, I've seen that a lot of small businesses and, for example, Duolingo, which is actually a very large business in language learning, are replacing their employees with AI instruments. Like small businesses are not using designer works, or they are not having a lot of social media marketing employees, because they can do it via ChatGPT or like of them AI models. And Duolingo, which is actually made for learning language, which is actually one of the most human aspects in our lives, is actually became an AI first company. I want to ask you if there are any ways to protect real employees of flesh and blood from AI companies.
Thank you very much for the question. Again, it might depend on national legal system as such. But what is again clear that if we look into commercial interests of businesses, a clear interest in automation, it is good and so on, so that the people will be able to create more value and not engage in very routine works and so on. And all the standard national protections apply from being laid down because of the staff reductions and so on, because the businesses have to generate value. But again, we see already the first optimistic victims of these steps when companies laid down persons saying that yes, AI will replace you and so on, such as an example of Klarna that laid down thousands of customer support employees. And then they tested the AI-ridden customer support with customers, and they saw how dissatisfied they were because of cold answers, lack of human interaction, errors, and so on. So then they had to invest much more to bring these persons back that were laid off. But of course, then they kept them for more complicated questions, customer support questions. So I think that there are certain lessons that businesses sometimes have to make, and to understand what is the real value of having human employees.
Thanks for the answer. It was very nice.
Thank you so much.
Thank you.
Yes, so I'm afraid that we cannot afford no more questions because of the time limitation, and time is always the biggest obstacle for the discussion, unfortunately. So thank you so much, dear Gintare. Thank you for your detailed speech and very interesting speech. We will now turn to our next speaker, and I'm glad and I'm really very, very happy to invite the next speaker to the floor. Laima Vaige she is an associate professor and senior lecturer at Uppsala University, Sweden. Her research focuses on private international law with a particular emphasis on international family law. She obtained PhD in international law at Mykolas Romeris University, Lithuania. So I think you are colleagues with Gintare, right? And another one in family law at Uppsala University. She is involved in several projects at the European Law Institute, including enhancing child protection, private international international law on affiliation and the EC's proposal on communication and extrajudicial administration of justice in cross-border family and succession matters. So meet Laima Vaiga. Laima, the floor is yours, and we are glad to see you today and to have you at our panel discussion today.
Hello, thank you so much for the invitation to participate in this conference. And precisely as Natalia just mentioned, I come from Lithuania originally, but I lived in Sweden for the last 10 years. Today, my presentation is actually on the states of emergency. I'm also a course director in the course of Democracy and Human Rights at Uppsala University. And now I'm going to share my slides. And in the meantime, I will also tell you how I found out yesterday that I have COVID, which shows the advantage of digitalization in this particular case, because I would never be able to participate in the conference had it been live. Okay, now do you see the slides and you don't see the notes?
Yes, we see the slides. Maybe we will try to switch them to know whether they switch well.
Yeah. Does it work?
Yeah, perfect.
Yeah,
perfect.
perfect.
We hope you feel yourself okay.
Yes, I'm relatively fine. I don't have
COVID, right?
any fever at the moment, and I think this is a good example of digitalization. But of course, there are many where you have to be cautious.
Okay.
So the COVID-19, as you know, was one of these examples where states announced the state of emergency. I think it was about 400 derogations under international human rights treaties announced, according to empirical studies. And the state of emergency is a temporary situation in which exceptional powers are granted to the executive and exceptional rules applied in response to and with a view to overcoming an extraordinary situation posing a fundamental threat to a country. So you can see in one sentence 3 times exceptional, extraordinary, really special, and a fundamental threat of this to the entire nation and life of the nation. This is a definition by the Venice Commission of the Council of Europe. And of course, there are some other definitions, but you can see that the idea is that it should be temporary, even though in the last perhaps 5 years it feels like a bit of a permanent state of emergency, which has been also criticized in the political theory, that these states should not be used in a sense that it becomes almost a permanent sense of emergency. States of emergency have been known since the times of the Roman law, where it was possible to grant the power to the dictator because that was needed. And of course, there were certain safeguards also introduced. It was used extensively in these times where the institutional balance gradually have changed. For instance, in the Weimar state, before Hitler came to power, it was used more than 250 times. So you can see that states of emergency can pave the way towards institutional disbalance and then a possibility to abuse human rights. But in many cases, when you have a state of emergency, such as global pandemic, perhaps, or a migration crisis or threat of terrorism, you don't really need to necessarily announce a derogation, because human rights treaties provide for certain possibilities to actually limit or restrict human rights already without announcing a derogation. We have exceptions to human rights, which are already available in the material of the convention. You can see in Article 4, for instance, that prohibition of forced and compulsory labor does not extend to any service exacted in case of an emergency. So if you have public service that is needed because now we have, let's say, war, armed conflict, threat of terrorism, that's that's exempted, that doesn't fall under the definition of compulsory labor. Then again, in many of the articles of the European Convention of Human Rights, you see that there is a possibility for restriction because these rights are not absolute. So the freedom of expression, freedom of assembly, respect for private and family life, there are certain possibilities to restrict them if there is a legitimate aim, if this is prescribed by law, and this is necessary and proportionate. So derogations are only left for the most extreme cases, and they are lawful. So we have a legal framework both in the International Covenant on Civil and Political Rights and the regional conventions. In case we have public emergency which threatens the life of the nation, and the formulation is quite similar in these legal frameworks, or independence or security of a state party in the American Convention on Human Rights, which has been more stringent actually and interpreted in a more stringent way with regards to derogations. Certain derogations are never allowed. So you cannot derogate from the right to life, right to be free from slavery or servitude, right to be free from torture, and right to be free from retroactive application of penal laws. However, as I mentioned, there are certain exceptions, even in these definitions, because right to life, of course, is non-derogable. But if life is lost during the acts of war, that does not fall under under this absolute right. Then it's an exception rather than a derogation or a limitation. Fundamental judicial guarantees such as fair trial, right to equality are also increasingly seen as non-derogable, especially under the American Convention on Human Rights, but then subsequently even the European Court of Human Rights also increasingly sees them as non-derogable rights. And these are the rights, of course, that can be affected in the state of emergencies in the digital area as well. Right to fair trial and right to equality, because digitalization poses these risks to, or potential risks to making sure that fair trial is available to everybody. Substantive and procedural conditions of these derogations are established in the Article 15 of the European Convention of Human Rights. And as I mentioned, the threshold itself is described as public emergency threatening the life of a nation, even though it has been explained that it could also be a certain region that is affected by potentially very high risk of violence or terrorism and things like that. The state may only take measures derogating from obligations under the convention to the extent strictly required by the situation itself. So it has to be more or less short in time and proportionate to the legitimate aim. And any derogations may not be inconsistent with obligations under International Human Rights Treaty. There is also a procedural condition that the state must inform the Secretary General of the Council of Europe. And that might seem, oh, it's just a formality, but it's really quite important, because the European Convention is the instrument of collective enforcement. So other states have to also know. So this mechanism is quite important. And sometimes, of course, when it's an emergency, there is no time to formulate these derogations. So it could be a little bit later, but not so much later as 4 months or 6 months. And I know that Ukraine has availed itself to many of the derogations under the European Convention of Human Rights, and in 2024 went down on these derogations. So now there are only certain derogations that are still available, which is of course a good thing, because states of emergency, they are dangerous in a sense that powers granted to the executive can become too strong and become normalized, the institutional balance changes, because usually the executive is only to execute laws rather than interpret or legislate. The threshold is rather strong under the convention, so the emergency must actually exist, be imminent, rather than be somewhere in the future. So climate change is one of these examples where there were certain discussions, but it's becoming actually more or less in some even European countries, it becomes a imminent danger, as we have seen with flooding in Valencia and other countries. So potentially climate change will also be there as a state of emergency. Must affect the whole of the region, even though it can also stem from certain districts or regions of the country. But the organized life of the community must be threatened, and no normal measures can deal with this kind of situation. So yeah, I already gave the example of COVID, where a lot of notifications of derogations under human rights treaties were submitted, not in respect of all of the countries. For instance, I live in Sweden and we did not have the state of emergency because it is not possible. The only possibility under the constitutional framework, because we don't have constitution, but we have constitutional acts. The only possibility is war. So it was not possible to announce the state of emergency under the constitution. And this is actually another issue that sometimes you have. State of emergency under Article 15 is the highest level of emergency. That's the state that allows for derogations. But you can also have de jure state of emergency under the Constitution, but not reaching the level of a threshold required by Article 15. And then you have de facto emergencies, which are to be discouraged according to the Venice Commission, because they are quite dangerous in a sense that states simply the government announces, now we have the state of emergency, but there is no parliamentary check, and there is no constitutional state of emergency, de jure state of emergency. So now, for some reason, it's a bit frozen. Okay. They have
maybe some problems with PowerPoint or other problems.
Yes, I think because it's not switching the screens, but let me just. Oh, okay, now it goes.
Oh, now it goes.
Yes. Do you see it now?
Yeah, negative changes, right?
Yes, great.
Okay.
Yes, so as I mentioned, the overuse of states of emergency have for a long time been discussed in both legal literature and political science as leading to a change of institutional balance, which means that more human rights violations will arise in long term. Potential rise of authoritarian tendencies. So you can see in the final report from International Law Association Committee on Human Rights in Times of Emergency from last year, they say even if the state of emergency is lawful, it will negatively affect enjoyment of individual human rights. So even in this highest level, if the threshold is met, all the substantive conditions are met, all the procedural conditions are met, and the international community is in a way happy with the lawfulness of the derogation, in a long term, it does have a negative effect on the enjoyment of human rights because of the change of the entire political culture and institutional balance. So, okay, now once again, not moving.
Never mind, we will wait.
Okay, now it moves. Yes, and the longer it lasts, of course, the longer, the bigger the risks may arise. The national courts usually, which are interested and have to be interested with the check on the executive, on the extraordinary powers of the executive to take measures, usually are quite permissive in the first stage of a state of emergency. Gradually, they become more stringent with regards to the measures of emergency. But also the international institutions and the European Court of Human Rights, who is also interested to check whether these derogations under Article 15 have been lawful, or restrictions and limitations of human rights, not via the mechanism of derogation, but via the usual restriction of a certain right, because you can have a state of emergency, but not reaching the level of a threshold of a derogation under Article 15, but the right can still be restricted with legitimate aim. So they are quite lenient in the first stage, but the longer the situation persists, the lesser justification there is for treating the situation as exceptional. And there is a certain deviation under the European Convention. Even prolonged emergencies may justify may be justified if they remain proportionate. So as I mentioned, there has to be extraordinary powers are given to the executive, meaning the government, the prime minister, the president, but there is a power check, and it is necessary. Parliamentary oversight, judicial power to check whether these states of emergencies are really necessary, or their emergency measures. Monitoring by the ombudsman and national human rights institutions, and finally monitoring by the media. So this is the times where freedom of expression, freedom of press, freedom of thought is extremely important, and also non-interference in this area of both the executive, but also the foreign interference. And this is something that has been only now discussed as a bigger threat as well. Then in particular, I think an interesting topic is elections under the states of emergency, because the right to vote, both the active aspects and the passive aspects of the right to vote under the convention, can also be limited or derogated from. And in many countries, it is constitutionally provided that elections are not held during the state of emergency because there are bigger problems to deal with. The Venice Commission recommends that if there is a state of emergency and elections are suspended during that time, you should provide a judicial review by independent court, and parliamentary majority should also be required for postponement decisions and then reviews of these postponement decisions. All parties and stakeholders should be involved, ideally before postponing elections, and it should be provided in the law in advance rather than during the states of emergency. They also recommend holding elections if emergency lasts for longer terms, for instance, more than a year. Of course, this is just a recommendation and not a strict requirement. And then they say, if there is a danger to observers of the elections, to the politicians, to the people themselves, while voting, consider internet voting and online observations of the elections. However, I think in the recent couple of years, there is a realization that AI, big tech AI, and foreign interference in the elections might lead to a future crisis. So I know that there have been certain studies done on internet elections in Ukraine, for instance. The Council of Europe has founded a study that came out last year, where the conclusions are that none of the existing internet voting systems actually fully satisfy the criteria at the moment. So I think this derogation still persists, and with regards to voting and the right to vote, and it is justified under the European Convention of Human Rights, or arguably justified because there are no such possibilities. Now, this is just an example of a convention on AI, human rights, democracy, and the rule of law, where you can see also this substantive condition under European Convention of Human Rights, Article 15, that is embedded as one of the substantive conditions for the derogations, is that you can never announce states of emergencies and derogate from international human rights that protect democracy and rule of law. And there is also a separate article that says that nothing in the convention can be construed as limiting, derogated from, or otherwise affecting human rights under international treaty law. So I'm actually on my last slide. I tried to make it shorter, so you can still have a break maybe. So the key takeaways from this presentation was that states of emergency always test democratic resilience and human rights. They have been criticized quite extensively, but of course we have to understand the context that first of all we have the emergency and then we have to respond to it with the states of emergency and the measures of emergency. The studies show that even lawful measures under states of emergency tend to have negative effects in the long term, especially because they change the institutional balance and they normalize big powers granted to the executive. I would also say that in the recent few years, there is a realization that it might be necessary to preserve offline safeguards or analog safeguards where they are vital. For instance, in terms of voting, right to vote. And by analog or offline safeguards, I mean these offline physical human control safeguards and human time, which at the moment seems like a luxury, of course, but the human time is really necessary for to preserve the vitality of these functions. And also emergencies end, but digital infrastructures remain. I didn't talk so much about these digital structures, but I have seen that it's on the schedule of the conference program, and in Sweden, and I know that in Lithuania, where I originally come from, and in Ukraine, you did have this development or kind of a boost of the digital structures, especially with regards to right to education, right to fair trial as well, which I think still remains. After the pandemic, Lithuanians still have the possibility to go to school online, which I think is quite extraordinary and interesting. And I know you have this in Ukraine as well. But they must always be designed to protect rights and democracy and to make sure that everybody can take part of the enjoyment of human rights. So that is it. Thank you so much. And I'm happy to answer any questions if you have some.
Thank you so much, dear Laima. A very, very interesting and up-to-date speech which you represented. I think that all of us who live in Ukraine, who come from Ukraine, but temporarily or constantly live abroad right now, we all feel all these issues which you raised. We feel them because they are so topical for us, because we face them constantly during last almost 4 years. And by the way, this is up to the question about the temporary, up to the requirement that emergency must be temporary, right? But our temporary emergency lasts for almost 4 years already. So yeah, we face all these issues constantly, unfortunately, and the issue which you raised about our elections, this issue is also very, very, discussable, very up to date, and our politicians always raise it when they, communicate with each other. But no one sees the optimal solution for it, unfortunately. I'm sorry, and I'm afraid that we do not have enough time for questions, but we have a couple of questions in our chat. So maybe very short commentaries from you and answering these questions. So the first question comes from our first speaker, Sergei Grishko. What interplays does Professor Weiger, so do you, see between Article 15 of the European Convention and Article 21 of the EACEA? So this is responsibility of states for internationally wrongful acts. This Article 21 says the wrongfulness of an act of a state is precluded if the act constitutes a lawful measure of self-defense taken in conformity with the Charter of the United Nations. So how can you comment this issue?
Wow, this is very, very interesting. I'm not sure I have the answer actually, because I have never researched in depth EACEA actually. So I think when we have such situation that you're actually facing, it's there is no question that this is the state of emergency. I mean, war is actually how to say, the very big exception, and here I think it depends. I mostly researched actually COVID-19 and other types of migration crisis where other types of international treaty documents come in, and they are super interesting and they are very necessary to analyze. I would still say that if you think from the perspective of the European Court of Human Rights, European Court of Human Rights actually always interprets the European Convention. So they would, of course, consider the EACEA. But I think it's a bit difficult to comment. I think it depends on what kind of right are we talking about, and in what kind of situation, what kind of context. I would say that they are mutually reinforcing each other, Article 15 and Article 21 of the EACEA. But at the same time, Article 21 extends the substantive condition. You can never justify the derogation if it violates international treaty law and obligations under other treaties. So they are mutually reinforcing. I don't see a conflict between them, and I think it depends on the context and on the right in hand.
Okay, thank you so much. Yeah, this issue is really, unanswerable, I think. Unanswerable in definite terms, in some particular terms. And this is not maths, this is not physics or something like that. These are very, very complicated human issues.
Так, пані та панове, 11:20, тому думаю, що ми можемо продовжувати, нагадаю, нашу панельну дискусію про права людини в цифрову еру. Ми в першій частинці вже почули про онлайн-судочинство, про штучний інтелект і про права людини в надзвичайних станах. В нас плановано ще дві
Now we're about to
доповіді.
have two more presentations, but unfortunately I don't yet see Miss Stephanie. Miss Stephanie, please, if you're here but you just named differently, please let us know. Unfortunately, I don't see Miss Stephanie here in the room.
Ми, мабуть, перейдемо до наступного доповідача.
So we're about to proceed with our next presenter.
To present our next speaker, Dr. Zuzanna Basel. She is an Associate Dean for Business at Southern New Hampshire University in the United States. She was a visiting professor at the Vietnam National University, Hanoi, and held various leadership positions in one of the largest financial service companies in the United States. Dr. Basel's current research interests are digital ethics, fintech, currencies, the future state of the financial industry, and mortgage markets. And today, she's gonna be presenting on sharenting in the age of AI. ethical challenges for child privacy, protection, and identity. So very eager to listen to what sharenting is. So Susanna, you have the floor, please.
Hello, everyone, and thank you for having me. It's a real pleasure, and thank you for listening to me. This is actually outside of my little bit of scope and of my research, and it's because our governor just issued a law which forbids cell phone usage in schools throughout the school day. And students are required to shut off their cell phones and put them in backpacks and not remove them even for lunches. And they have to remove them after school day ends, which created a lot of withdrawal. So I looked at how do they cope with social media, because I have a teenager and an 11-year-old who are not on social media, but it impacted a lot of people who earn money on social media as students. So what is actually sharenting? I'm not going to share a full screen because I realized that if I do, then it sometimes glitches. So it is practice of parents posting online and the content online about their children, especially parenting, which is for profit, and you monetize in hopes of gaining regular revenue stream. And then there is the non-commercial one, which majority of us are very familiar with, where you share with friends, parents, connecting with community to retain connections, and you document several milestones. A lot of these are considered often very innocent, oh, look, Johnny, look how he grew. He looks awesome. But we don't realize that even non-commercial sharenting can lead to ethical consequences and harm children. We need consent from young children that often don't have a say in what we post about them online. We risk privacy of oversharing. There is an impact on the child. We can do exposure and embarrassment of the child. And there is minimal oversight of regulation for personal accounts. What do we post online? So, especially when we are looking at the privacy, we often, in non-commercial sharenting, there could be posting of some stuff that perhaps shouldn't be online. So I call it the happy birthday sharing. This is sharing when somebody goes to any kind of parties and they take pictures, and then the photos are taken at sports event or parties, private parties, and then they post them on personal social media. And what are actually the laws that protect us when somebody decides to post on Instagram from their birthday party? You have the right to privacy, where somebody posts a video that is compromising and sensitive. And it's a private moment that can violate your privacy. Then you have the right to publicity. And if the person is taking it for profit and is gaining profit, if they have their own vlogging business and they're posting it for publicity, then you can actually ask them to take it down. Anyone has to obey by terms of service of social media. So any platform they're posting it on, they have to know the terms of the service of the social media and obey by all the rules and regulations of that particular social media platform. If they don't, they're violating it. And then there's the lack of consent and asking for permission. If you have any children under the age of 13, the parent and guardians attending any events should always consent to social media posts, either verbally or in a written form, even in a private event, which I have not seen many people do. The potential risks here are that we have seen is stalking or family disputes and even criminal charges that could have been brought up. We have seen that some people are using social media to scan for these personal accounts for scanning for photos to search for in case of family disputes for children. So that's just for non-commercial sharing. There are rights and responsibilities when you're taking pictures at private events. We are all in education, and there are several privacy laws in education, both in US and in EU or Europe, and I will start with the US. So in the US, actually, there's FERPA, which is Family Educational Rights and Privacy Act, which protects personally identifiable information within education records, including student information collected on school divices, and allows for the disclosure of directory information unless parents have requested to be withheld. So every year you receive a form which you have to sign that you're okay to share your picture of your child online on their social media. So you assume that it's not going to be misused for commercial purposes. It's there for social media if they are doing fun activities and so forth. You consent that it can be posted on social media. There's Children Online Privacy Protection Act, which is overseen by the Federal Trade Commission. That's interesting to me. And it safeguards against the unauthorized collection and use of minors' sensitive data under the age 13. So under the age 13, they put additional barriers. And pretty much this actually tells you have to, as an educational institution, put online how do you collect data, what do you collect for data, and how it is stored. So every single institution has to have who do they share their data from. So if you put ID on, or if you have any social media accounts, those have to be readily available on the landing page of the institution. And then there's CIPA, which is Children's Internet Protection Act of 2000, which regulates the children's access to objectionable materials on the internet, particularly in school libraries. And that's if the library is participating in Federal Communication Commission and they want to receive the E-rate discount program, then they have to obey by rules of the Federal Communication Commission and remove any objectionable materials on the internet. If you're adult over 17, especially in high schools, you can ask to have certain barriers removed. Now, in EU, there are not as many specific ones, but as you know, there's the General Data Protection Regulation, and as of May 25, 2018, all organizations were required to be compliant, and this actually covers most education privacy needs. So it established the protection for privacy and security of personal data about individuals in European Economic Area, and it's based on certain EEA organizations that process the personal data. And in 2020, the Council of Europe Consultative Committee and Convention actually issued a new guideline that the GDPR is, in today's world, not enough. And there should be initially in the world. And they asked to do additional children's data protection in an education setting, but it is just guidelines. It is not a law yet. So since 2022, the Council of Europe published study Artificial Intelligence and Education, a critical view through the lens of human rights and democracy, and they're trying to work into increasing the children's data protection in education. And they want to make it from guidelines to a law. Now, when we talk about child labor in 21st century, all of us still have that old picture of, Victorian era in mining and then children working in factories. But majority of child labor now happens online, and it's linked to subscribe, like, comment, and share. unfortunately. So when we look at commercial sharenting, it is the number of family influencers, and it is very hard to log and see where it is. There's family vlogging, van life, and influencing families, and they are on multiple platforms. And we have, for example, just in the terms of accounts, there's 250 accounts directly linked to van life, where family lives in a van. It's like Victorian family living in one room house, right? And we are looking at all social media platforms. There are about 70,000 to 200,000 accounts that are directly linked to family life. Are you okay?
Yeah. That's just noises. Someone did not switch.
I'm sorry. To 200,000 accounts linked directly to children. If they have average 3 children, we're talking about 220,000 minors that are impacted by this vlogging. Now, there are several ways to make money online from this, right? And it's changed. Before, we always thought about online making money from views. So we were selling views when you made the videos. And children are part of this earning where they made the videos. But that changed in 2024. Now it's tipping and gifting. So the family actively puts these children up front, and they are calling it now the decade of beggars. So they're asking for gifts and tips and please help our family. So they're calling it the new era of beggars online. The second one is brand deals or merchandising. So the creators are asking for commissions on sales, for any brand deals they do. They review content, produce content featuring several brands. And if you didn't know, that actually pays a lot of money. For example, Ryan Kaji from Ryan's World is the highest earner, and he was 10 years old in 2020. And that year he earned $30 million by opening gifts. And his parents made him work several hours a week. They capped the hours for him so he can still do homeschool. But when people see these numbers and they say, okay, my child can earn me $30 million a year. We are talking a lot of money in online creation. So how can you protect minors from online work? Well, both EU and US really don't have specific online laws. There's fair labor standards from 1944, but that's insufficient because it was enacted when they were looking at minors working fields and factories. And it specifically talks about well-being and homeschooling, but if it talks about well-being and educational opportunities, but parents can provide homeschooling and well-being is missed. So that's insufficient for vlogging. Then we have child entertainment laws of the Coogan law, which employers must deposit the 15% of minors' gross earnings into trust accounts. When the minor reaches 18, they will get access to it. It is very important law, but that's only applicable in certain states in United States currently, and only applies in some of the states into entertainment industry. And then we have the General United Nations Convention on Rights of the Child, which was adopted in 1989. And that should cover all children, which emphasizes the child rights to privacy, protection from exploitation, and the rights to participate in decision affecting their lives. And decision-making concerning children, their best interest must be primary consideration. And the governments must ensure children can live and grow to their full potential, both physically and mentally. But again, that would require that somebody steps in and says, okay, you are not doing the best interest and you don't have the primary concentration of your child in mind. But they can argue that we do. The child is getting what they need. That changes when you're 18. What can you do when you're 18? In Europe, under the GDPR, individuals can request the removal of all content from social media websites. But that requires them to actually go and physically ask the social media where their parents posted to remove that content. The parents still own the content, but wherever there is an image, they can say, this image belongs to me. Can you remove it? Because you are the social media platform, you need to remove it. So that they can do that. In US, it depends on the state. In California, they're always ahead in child protection. So they led the way in legal rights for individuals where minors at the time of filming, their likeness can be removed from the content. And I'm not sure if you followed the high-profile case of Ruby Franke and her 8 passengers, but Utah is another state that led the way with their UTSB 322 in March 2025. And they also have the right to return and control their own images when they are 18. If we look at United States state by state, there is 51 states, but only 16 introduced or enacted any type of legislation prior to 2012 and 2025. For example, I live in New Hampshire and there's no protection for children online whatsoever. So they would have to default to the United Nations privacy laws if their parents lived in New Hampshire and did content online. California was on the forefront, and when they first introduced the laws protecting children online, a lot of content creators moved to Texas, which sadly is still not protecting anyone online. And they don't even have the law where they have to deposit 15% for children into trust funds to protect them financially. So if we look at AI, that actually made the situation even worse, because now the child is working in an environment where a different type of algorithm decides what is shared online about the child. So how AI works is a little bit different. It blurs the identities. AI and humans, we can differentiate as humans between adults and children when we look at content. AI doesn't. AI distinguishes by looking at mimics how the person acts, how the person speaks. So the AI identifies difference between child and adult online by the way they speak, by the way they behave, not by how they look. They have to look at how they behave online. So if the child is reading from a script, which majority of the child minors working in the family vlogs and van lives do, the AI might not see there is a difference between a child and an adult, which complicates the issue of consent and agency. Then there is digital permanence. AI is constantly learning. So it takes all the data, retains it, and learns from it, which it learns the small patterns and behaviors of children. And once the content is shared, AI will use it over and over and reshare it with other learning systems across their network. So there's always a digital permanence. And then there is lack of informed consent. A child cannot give consent for AI to use their data for training purposes. And the child does not fully understand the AI curated digital space. So we talk about right to privacy, and we have to give you have to give that consent of using the data. Well, child cannot do that. It is up to parents and guardians that need to be ethically responsible and give the consent. But if they're earning money off of the child, they'll be hesitant to do so. Then there is the AI-driven risks, again, the algorithm amplifications. So AI uses algorithms to boost engagements. So they will prioritize emotionally resonant content and drive actively parents to it. So if something is cute and quirky, they will drive the content and viewers to it. Then we have targeted dissemination. AI-powered recommenders, system may actually channel some of the child content to users with harmful intentions. Then you have the loss of digital autonomy. So AI can retain child profiles and it can impact their future educational and employment opportunities. So what looks fun and cute when you're 3 can harm you when you're applying for a job. 70% of employers, according to Staffing Hub, up to 70% of employers are scanning social media profiles now. So if your parents were old, and then you have deep fakes and synthetic media. So generative AI tools now manipulate images and videos, and they can create deep fakes and synthetic content. If you ever played any videos on your cell phone and there was, games on your cell phones and you had a pop-up with a video of advertisement and there was a famous person selling you a diet pill or selling you another video game, those are generative AI deepfakes. But, as psychologist Robert Kozlovitz notes, when engagement means income, the pressure to share more becomes overwhelming. So then there's the mental health impact compounded by AI, and this is where it really got kind of weird doing the research. There's the misinformation and disinformation. AI can generate persuasive false content, making it hard for children to distinguish truth from falsehoods, and it affects their critical thinking. So some of these articles were very dark, and they said that really, truly, we need to have very set AI policy because child cannot distinguish between misinformation and disinformation. Then there is the mental and emotional health, because AI-powered algorithms and unrealistic beauty standards can contribute to negative self-perception and low self-esteem. AI companions. There are AI chatbots, and some of the minors chat with these AI chatbots, and Harvard did a study where they were chatting with the chatbots, and the chatbot cannot distinguish between inappropriate dialogue where they don't recognize where the child talks about self-harm or violence towards others. They just continue the conversation without correcting it. So that puts unrealistic and dangerous situations on a lot of minors. And then there are still algorithmic biases and prejudices because a lot of the AI data is created in and collected in one specific, for example, in one specific region or area. So it still reinforces the existing racial, gender, and socioeconomic prejudices. And that's what is pushed towards the minor at the end. So why is it worth it? So when we look at the newest, they're trying to collect data, but the teenagers, when we look at teenagers who look at online, we have seen that hate speech increased at 53%. 53% of teenagers experience hate speech. Cyberbullying is up. Threats of violence are up on social media. We have increased toxic content that was recommended to 16-year-old TikTok watching TikToks. But why do people still do it? Why is it worth it? Because that's where people are, that's where users are, and that's where everyone sees where the money is. And that's why everyone thinks it's going to be worth it to be on social media. And everyone is looking at the next big fix and next quick money. But we need to have rules and regulation in place to protect against the harmful information. And right now, we just don't have the laws that protect everyone. Any questions?
Susanna, thank you so much for the incredible, very interesting speech. That's really, I have never heard of sharenting before. Of course, I am online, but I know that there is even a special term coined for it. So that's really an interesting problem. In general, during the Kharkiv International Legal Forum, we have been discussing privacy a lot and how the privacy changes in the world of digital technologies, and what's even left of privacy in the world where everyone shares almost every detail of his life. So thank you so much. That was very interesting. Do we have any questions from the audience? No? If there is no questions, so it was a great pleasure. Susanna, thank you so much for being with us. Incredibly interesting research and incredibly interesting data and numbers. So it was fascinating. Thank you so much.
Thank you for having me.
Thank you.
Thank you.
And now we can then move on to our next speaker. And that is Stephanie Laulescello, who is professor of European law and reform and also head of the School of Law at University of Central Lancashire, Cyprus. She is director of the Jean Monnet Center of Excellence for the Rule of Law and European Values and visiting professor at the United Nations Institute for Training and Research. And Stephanie is going to be talking about transatlantic rule of law and European values and needs analysis. Stephanie, glad to see you. Hello, the floor is yours.
Hi, everyone. Thank you. Thank you for the introduction. Thank you for having me again. I think it's the third year in a row. Thank you to the previous speaker, Susanna. I also thought that the presentation was extremely insightful, and I'm hoping perhaps that the organizers can share presentations with all of us, because I would like to, I missed the beginning of the presentation, so I would have liked to see the whole presentation. So it would be good to share presentations among participants. Thank you. So I prepared something, well, which is actually a very good transition to what we heard before, because I'm also going to look at the relations transatlantic in comparison. But I think for the moment, I mean, to start with, I will basically paint the broader picture. Why is it that the rule of law, generally speaking, is relevant to the transatlantic relations? So I think we can now talk about transatlantic rule of law and European values as opposed to the center of the rule of law and European values. So that becomes a TROLEF instead of CROLEF. By the way, CROLEF is not a Jean Monnet Center anymore, in the sense that the funding run out. You know, it only goes for 3 years, 3.5 years. Now, however, nevertheless, the Center of Excellence is still active and continues beyond the Jean Monnet funding. So I'd like to share a few ideas with you, and first of all, a few data with you, and then some ideas. And so the overall question is, how is transatlantic rule of law and European values relevant to the digital era? which is the topic of the conference today, and the subtitle being Value Foundations and Protection Mechanisms. And basically, there are three pillars which are intertwined in this presentation. The first one is the rule of law and European values focus in the digital world. So at Krolev, we have worked a lot on that, including with some colleagues from your institution and from your Jean Monnet Center of Excellence. But we also have worked a lot on emergency laws and the impact of smart systems as well as AI development and AI systems onto emergency laws. And now I propose to look at this into transatlantic relations. So primarily between the EU and the US. It's just work in progress, so I haven't really done much yet about that, but I do see that there is a need for, as presented by the previous speaker, for more comparison between the two. And I will explain to you why at a more fundamental level. So basically blending all these topics. Now, why are we talking about smart information systems and AI systems as being so essential for human rights issues, as well as democratic values and the rule of law principles? Simply because, of course, this has been documented now quite well for the past 5 to 10 years. Impact of smart information systems and AI systems on the triangular relationship of the rule of law, democracy, and human rights is massive. And you can see multiple examples of this. Here on the slide, you have a number of examples. I think that the most relevant to what we're doing at the moment is probably democracy and freedom of thought, as well as misinformation, disinformation, and malinformation. But there is also the increased trends of surveillance and intelligence, which is something that is along the line of the current priorities in the EU and in the US, which is security. So that one is on the rise too. But if you think about it and you look at the main characteristics of smart information systems and AI systems understood narrowly in the sense of understood technically, then there is an issue because as previously presented, the way AI systems operate is by being non-transparent. The word blurred was previously used, and that this is a very accurate word to describe the way AI systems operate. We usually refer also to opacity. So the opacity of the development of AI systems and of the operations of AI systems. So this is a problem when you want to uphold the rule of law principles, particularly of transparency and human rights protection. So opacity is the first issue. The second characteristic of smart information systems and AI systems is the one of unpredictability. In other words, you never know how a technology is going to develop and how it's going to end up. So this high amount of unpredictability and increased risk is one of the characteristics of AI systems. And of course, they carry also the features of big data, which is that you don't really know who is in charge. So neither the developer, nor the deployer, nor the user can normally know in advance how the system will react to a given set of problems or data situations and inputs. This is due particularly to the constant technological progress. But those constant technological progress, they need to be also benchmarked vis-à-vis, vis-à-vis, first of all, legal developments and ethical developments that probably need to be accelerated. They are way behind technological progress, but also increasingly benchmarked vis-à-vis a very volatile political context globally. So there is less and less stability and less predictability and less safety, security and safety in the way the world is moving forward. So that is also important when you know that the technology itself is progressing at a very high pace. In the meantime, as we heard before with respect to children, our digital life is there for all of us. Our digital footprint is there for all of us. This leaves a number of questions unanswered, in particular when it comes to the legal and ethical consequences of the lack of accountability and of reliability of AI systems. And the questions, the very legalistic questions of, who has the most oversight, who has control over risks, how to conduct risk assessment, where does this leave the end user, and where does this leave human rights, generally speaking? And is the legal framework in place currently sufficient to counter the risks of AI from the perspective of rights? And this is not a new discussion. I mean, the discussion was ongoing in the EU and the US for the past at least 20 years. I mean, the first case we could say about the development of technology in the EU is a case from the 1960s. We probably tend to forget it, but the protection of privacy is something which has always been at the forefront of the development of technology and innovation in different ways and different fields. Now, looking at it from the perspective of privacy is not enough, and this was also clearly demonstrated in the previous presentation. A clear description of how AI systems function and how human behavior is being affected. So privacy concerns are, of course, extremely important, and they have been addressed very thoroughly during in the GDPR, which is an interesting model, as well as a number of other countries have equivalents. But those considerations are not sufficient because now, as I said, due to the volatility of the world at the moment, there is much more emphasis on intelligence and the use of intelligence for dual purposes, which means that it could be a military use vis-a-vis a civil use. So the two could happen without us even realizing it, as well as risks around the proper use of data, which is a fundamental use to prevent a crisis from occurring, particularly data crises or massive data losses, for example, or other crises and emergency situation. And the second important aspect here is that I approach is mostly EU-centered because this is what I know best. But what about the same principles and values outside of the EU? So it's as if the data is protected within the EU, but then, they get out of the EU. And then what next? So unfortunately, data are global. Most of the data deployers and developers are outside of EU. We know that well. Most of the AI systems development are also outside of the EU. So the free movement or the free flow of data should not be undermined because data is global and data can be faster than anything else. And therefore, this is something that we need to be taking into account. So I've done some work in the past on how to express legal terms. So particularly in rule of law related terms. And,
well, we are talking about developments such as profiling or prediction of behaviors, influencing of opinions or choices, predicting policing, mass tracking, surveillance, and micro-targeting, as we said before. Biases, discrimination, and distorted access to information are concerned. These are all manifestations of phenomena of modern society that can be addressed via rule of law principles and values, provided they are adjusted to that digital world that we need. So we have seen in the past 10 years a proliferation of regulation at the EU level, the European level, the regional level, as well as at the global level. And this is something that we are going to turn to now. Now, inside the European Digital Legal Order, broadly speaking, EU plus, so EU and Council of Europe, basically, we have had a number of developments in the past few years, which are very important. And the first one is, of course, the new acts at the EU level, the EU AI Act, as well as the Council of Europe Framework Convention on AI and Human Rights, Democracy, and the Rule of Law, which are supposed to address some of the questions that we are posing today, but with a different approach. There is also more and more emphasis on the impact of AI on fundamental human rights, with risk assessments and impact assessments, as well as discussions around new fundamental rights, which I think is going to be covered by Julia. But if not, I'm sure that other colleagues will look at it. So I'm not going to look at new rights today. But basically, we have our old and at risk and then endangered usual international legal order there, which is in the European legal order, enshrined in international law instruments as well as European law instruments or EU law instruments, such as the EU Charter or the European Convention on Human Rights, as well as the UN Charter and the likes. So these are, although they are a threat today, these are the base. They remain the same. How to uphold and protect the nature and the scope of fundamental human rights, rule of law principles, and democratic values. So the ultimate goal remains the same. Now, in the EU or in the EU plus, so in Europe, we have had a number of different approaches. So we have made progress on having more uniform definition of AI and AI systems, and we have made progress also to adopting more human-centered approaches, but that may not be the same as a human rights-based approach. So there's a difference there. If you look at the latest instruments such as the EU AI Act, but also the Digital Markets Act or the Digital Services Act, and then, of course, in addition to the GDPR, then you find risk-based EU instruments. If you look at the framework approach of the Council of Europe, this is an interesting approach as well, with a number of underlying principles, which are very interesting. And they also tend to promote a more human-centered development of AI to the benefit of the rule. We need to look at existing rights and see how this can be best protected. Now, I'm not going to say too much about the EU AI Act because I'm sure that other speakers will actually develop that too. But basically, there are specific developments, AI system developments that are banned, the ones that are considered to be too interfering with a human-centered approach, particularly when it threatens citizens' rights, such as facial recognition databases, emotion recognition in certain places, or the manipulation of human behavior. So those systems are banned in the EU. It may be more difficult to actually determine what are those systems, but the principle is there. There is banning. And then there is limitation particularly on the use of biometric identification systems by law enforcement authorities across the EU, as well as a number of obligations for high-risk systems. So a system must first be assessed as being high risk to then fall under those provisions. And you find, of course, in the high-risk systems, all the systems that would have a potential impact or risk of harm on fundamental rights, rule of law, and democracy, as well as a number of other principles and sectors. Transparency is being enhanced if we can hope for that, as well as a number of transparency requirements for general purpose AI are set out. This needs to be balanced vis-à-vis the importance of development of AI systems in Europe to be able to benchmark vis-à-vis the United States or China or India or big players in the fields of technologies. Now, I'm afraid to say that in the past couple of weeks, there have been vocal calls to pause the implementation of the EU AI Act in Brussels because it's just too complex. I mean, I don't think that every member state of the EU is going to be able to abide by the timeline that you have here on the screen. If I look at Cyprus, nothing has happened yet, or nothing significant has happened yet from the point of view of regulating or let's say making sure of the legal system, of the national legal order. Of course, being a regulation, there should be no issue there, but it's one thing to say that a regulation, a new regulation is part of is directly applicable and generally applicable to all. It's another issue to make sure that everyone abides by the provisions. And I think that this is a real challenge. So there have been calls to pause the implementation, which is something that we need to turn to, as well as the Council of Europe Framework Convention on AI and Human Rights, Democracy, and the Rule of Law is slowly gaining signatures, but very slowly. And in any case, it's to be noted the role of national security in particular. So whether they're presented as rule of law principles or as enshrined into a framework convention, the principles are more or less equivalent. You can see them here on both sides of the slides, and you can see that we find transparency, accountability, equality, privacy, as well as safe innovation, but also human dignity as being the main ones. So the impact of artificial intelligence systems on fundamental human rights within the European legal order is quite well documented now. And I'm glad that it was touched upon by the previous speaker, in the sense that by focusing on children, you focus on the most viable and the most essential of all the human rights. Here's a list of human rights that are potentially affected by AI systems across Europe and across instruments, and we can do cross-cutting impact. In other words, it's not that AI systems will impact those rights separately. They will probably impact them all together. So if you take the right to privacy and family life, of course you have children's rights here, for example. So we have a number of solutions to offer in Europe to examples of AI risky human rights impacts, particularly when it comes to public spaces. So there are a number of things that one can do based on privacy and based on existing legal instruments. But what I really wanted to conclude with is what happens when the data is actually traveling outside of the EU. So let's take the GDPR for the purpose of comparison here, which is something that happens daily. And of course, it happens by default. Our data travel by default. So I've chosen the transatlantic dimension to do this, and I've chosen to focus on the EU-US relations when it comes to the transfer of data. Because we are in times of rule of law backsliding, and therefore we need to wonder about rule of law and European values outside of the EU. And there is a very interesting case that I wanted to share with you. It's a brand new case. It was issued by the General Court of the Court of Justice of the European Union a couple of weeks ago, and it was an expected case. Maybe some of you are familiar with the Schrems jurisprudence already. Well, now we have a new Mr. Schrem. His name is Mr. Latombe. And Mr. Latombe was equally unhappy with the way his data are being handed over to US companies and US systems, that he basically challenged the new adequacy notice between the EU and the US. So this was an action for annulment of the new framework for the transfer of personal data between the EU and the US. It is a Commission decision of the 10th of July 2023. It is called an adequacy notice or decision, and it confirms the safe transfer of data between the EU and the USA. Some of you may know that this is an ongoing story, and it's a legal saga, because the two previous versions of the adequacy decision were struck down by the Court of Justice of the European Union in Schrems 1 and Schrems 2. Because the Court of Justice of the European Union had found that the two previous adequacy decisions were not protecting fundamental human rights according to EU law to an equivalent level in the USA. So they had been struck down and found invalid, hence the new adequacy decision, which Mr. Latombe challenged. So what changed in between? Why are we challenging the new adequacy decision, which in the eyes of the European Commission is safe enough to transfer data from the EU to the USA and vice versa? Well, because exactly what we said, we live in a world of instability and uncertainties. We live in a world of backsliding of the rule of law, and of blurring of the separation of powers across the world. And in this specific instance, there have been a number of changes to public services in the US, but also law enforcement systems in the US that were challenged by Mr. Latombe as being potential threats to human rights protection and personal data protection coming from the EU. One example is the strengthening of the privacy safeguards for activities carried out by US-based intelligence agencies. This is why I referred to intelligence services before as being one of the major growing threats to human rights in this modern world, as well as the competencies and the powers of the quasi-judicial bodies or judicial bodies like courts that are going to review judicially the transfer of data and the protection of personal data. So in the US, there was a change in the way judicial review before the Data Protection Review Court happens. And those changes were made primarily by executive orders or regulation, so not via the legislative powers. So therefore, the independence of the whole system for the review of the protection of personal data was found, or allegedly by the plaintiff, to be at risk. And those practices in public services, public administration in the US or a judicial or public services, public administration, and law enforcement practices may be considered not to be in line with EU standards, particularly the handling of data collection in bulk, so big data, and in transit, and the difficulty or the lack of prior authorization from an independent authority for this transfer of data to take place. Now, the General Court dismissed the action, finding that there are sufficient safeguards to be found in the US system to assume, presume, and confirm the safe transfer of data, personal data from the EU, of EU citizens, to the US, and that there were sufficient safeguards in place in the review process of the adequacy decision and its application and its use. Particularly, the court refers to ex post judicial oversight available in the US, including for bulk data collection. Now, this is a typical example of technology. Because although the court was very quick in turning in the judgment, I mean, imagine, this is the adequacy decision is 2 years old. You have a couple of months to challenge it. So the court really took not even 2 years to do the work. So from that point of view, this is very proper. But the court can only do what it has been asked to do. So the challenge was about the action was about the challenge of the adequacy decision at that precise moment, 7th of July, 10th of July, 2023. So that means that not all instruments that we have been discussing so far were in force at that point. So there is a need for needs analysis and an impact assessment of a combined GDPR and AI Act, Human Rights Compliance Review. And this is not something which the court could do simply because it wasn't equipped to do so. It wasn't equipped because the request was not equipped to do so either. Now, we all know that, especially lately, massive amounts of data and growing massive amounts of data are collected and transferred in bulk by automated systems, smart systems, AI systems, transatlantic. So provided AI systems are used for those transfer of data, then these are now regulated by the EU AI Act, among others, could also be the DSA and the DMA, and there are categories of risks that are referred to before, the banning, the limiting, or the regulating. So the EU-US adequacy decision notice that we spoke about predates the entry into force of the EU AI Act and predates a number of changes in the executive practices by the new Trump administration. So there is a need to review the GDPR framework's application outside of the EU in line of developments in AI systems, which impact the operations of the public administration and law enforcement practices and agencies in countries outside of the EU, with which we have a massive exchange of information states that benefit from need to be reviewed constantly, monitored constantly, and not only under the GDPR. Particularly, there is a need to do so in the context of emergency laws. And more emergency laws or orders or executive practices and measures are taken across the world, given the current context, current threats. So human rights and risk of major data breaches exist, and they have materialized in a number of ways, whether it is via cybersecurity threats or practices, public practices or private practices. So this is what a level of human rights protection equivalent to the EU would require, in my view. And I will stop with this. This is something I hope I will inspire you for further research. And I'm happy to get in touch with anyone who would like to think about that. Thank you.
Stephanie, thank you so much for such an elaborate analysis and for a bird's eye overview of the problem of human rights and extraterritorial issues with regard to the protection of privacy, because really we live in a global world and information flows across borders, so we need to have an aligned approach in different jurisdictions so that we be sure that our privacy is protected effectively. Thank you so much. So is there any questions in the audience to the Stephanie? So no, there are no questions. Stephanie, thank you so much once again for being with us.
Look at the chat.
Oh, okay. We have a question from Sergey. Sergey, you can just voice your question.
Thank you very much, Bogdan. So the question is, can the human dignity and human rights be protected while maintaining the competitive edge in the digital age vis-a-vis totalitarian and increasingly authoritarian USA?
Thank you for this. Yes, of course. I mean, this is the gist of the matter. So I don't have an answer, obviously. But I mean, what I pointed are the dangers if we don't do what you're just saying, basically. Now, the EU has no other choice but to recognize the importance of the competitive edge, particularly in the digital transition. I think it's quite clear that the EU wants to equip itself with enough innovation to actually be able to face the giants that the US and China are when it comes to technologies. And we are, let's face it, we cannot cope. So we have good examples and good practices, but what the EU is able to invest into this competitive edge in the field of digital transition is peanuts compared to what China or the US are currently investing in the field. So we need to rectify that. And I think that's probably why there are calls to pause the implementation of the EU AI Act, because there are realizations that the cost to the innovation and competition aspect of the digital transition is just too high. And this is an issue because we already have made compromises. So when the EU AI Act was negotiated at the EU level, clearly there was a preference for a human rights-based approach for the Act, which was not doable because you had to balance the protection of personal data and human rights with innovation and competitive advantage. So that's why the risk-based approach was actually chosen. So we have already moved on and compromised in a way on human dignity and all other human rights. But in fact, it's probably not enough if you want to be able to compete globally. There is a very good example of an EU success story, which is the French AI developer called Mistral. Don't know if you are aware of it, and they have their own equivalent of ChatGPT. It's called Chat, and in English Chat, but in French it's le chat, the cat, basically. So this is a great example of how a European or an EU-based startup can, within a couple of years, attract millions and millions, even billions of euros in funds. So that is a success story. But we need more of those, because as long as the EU will be dependent on the AI systems created outside of the EU, we will have that conflict. So our top priority is probably to also develop our own AI systems as well as our own smart information systems, and that includes platforms for social media and other platforms and intermediaries that we need in order to enhance human rights and democracy, to fight misinformation, for example. As long as we are able to have that policy and that objective, then we will depend on super China and super USA, no matter what happens at the democratic or political level there. So this is a call to the European Commission. I've related to them too. I mean, to actually create our own AI systems and our own social media platforms to be able to fight misinformation, but also to be more competitive. Easier said than done, of course, in today's world.
Thank you, Stephanie. Thank you, Serhiu, for a very deep question. And it seems to me that it relates to a even broader concept known as strategic independence, which relates not just the chips and production of different information technologies, but also the algorithms and development of AI. So that's an issue of strategic in the EU, and that's a very, very harsh thing.
In that sense,
thank you
it's a
so
bit the
much.
same as the discussion around energy. In that sense, it's the same type of discussion to become more independent and strategically independent, but there is no need to face those global threats at the same time, because security is now on top of the agenda, as we said before. But the two are linked. You cannot do security without AI systems.
Thank you, Stephanie. Are there any other questions or comments? Thank you so much. Thank you. Отож, наступним спікером мала бути
So, dear colleagues, our next speaker was supposed to be Ms. Yulia Smeteva. However, due to some family circumstances, she will not be able to join us today. Therefore, just to wrap up this panel discussion, which will continue tomorrow, so just to wrap up our today's session, I want to remind you that along with invitation to this discussion, we also shared with you our action plan to improve Ukrainian legislation, legal and business practices in view of various issues caused and shaped by I probably will now share this action plan on the screen, remind you how they look like. These action plans are just a very general outline of challenges and issues we need to pay attention to in order to adapt our existing regulatory framework to new challenges brought upon by development of digital technologies. And here we have identified such areas as improving legislation, development of legal practice, responsible business practices, innovative ecosystem, and we have identified some expected outcomes and suggested stakeholders whom we need to engage in order to implement these actions. So, if you have any feedback or questions now, you have chance to share them. Please raise your hand. If you don't have any feedback for now, you can look through these documents again, as they are attached to the letters you've received along with invitations, and please feel free to share your feedback and opinion in a response email. We want feedback. We need all justified and motivated and reasoned feedbacks will be reflected, and we will consider including you as a co-author of this action plan. So we won't disregard any input. We strictly comply copyright regulations and we really want to reflect all inputs. So if you have any feedback, please feel free to share. Now is a good chance to share it. If no, then, okay, I don't see any hands raised. Well, if we don't have any feedback for now, then I just want to extend my sincere gratitude to everyone for your attention. Let me remind you that tomorrow, on September 26th, we will continue our panel discussion, Human Rights in Digital Era, Value Foundation and Protection Mechanisms. So we will be waiting for you tomorrow at 9 a.m. Kyiv time, and we will discuss ethical violations in personal data processing AI system from a point of view of regulators. We will talk about a model of AI laws for ethical legislation, strategic recommendations. We will talk about personal autonomy as a legal value in the light of technologies. We will talk about privacy of correspondence and telephone conversations in light of modern digital technologies. Thank you so much for joining us today. I hope you're not disappointed and you will join us tomorrow as well. Thank you so much, especially grateful to our amazing speakers, everyone who proactively participated in the event, and please take care and wish you a nice
Дякую, на все
rest of
добре.
На все
Бережіть
добре.
себе, на все добре.
Дякую, до побачення.
До побачення.
Дякую.
Всього найкращого. Так, ми можемо виключати запис.